on video. It's off now.
How many people do you have? When do you know when to? That's it. So we just kick off then. How do you move slides?
Just next slide and then yeah.
Okay. I can't have your mouse and just click. It's fine. Let's start. Good morning, ladies and gentlemen. Welcome to today's session where we'll be discussing tax and land considerations in structuring and operating infrastructure and PPP projects. I'll kick this off with the first session where we'll be looking at tax considerations, and my colleague Nicole will then discuss the land issues. So in terms of what you're going to cover today, move to the next slide. We'll start with an overview of the nature of legal entities that can be used to implement these types of projects. We then look at funding, how these projects are funded from a tax perspective. We look at the operational phase and the tax incentives that are usually applicable to some of these large-scale projects. We'll also look at how to structure EPC contracts and some of the tax risks that we usually come across, extraction and exit as well. So starting off with legal entity, which is the next slide. Broadly in Kenya, there are two types of vehicles which can be used to implement PPP and infrastructure projects. And it's broadly either a branch or foreign entity or a subsidiary, which will be a locally incorporated company. There are differences from a legal and a tax perspective, as you will see from this slide. And whereas there could be some tax advantages in various cases, depending on the type of project, to structure and use a branch, for example, there are regulatory considerations that will need to be looked at before deciding on the type of entity. Therefore, for example, for a PPP project, it is not possible to have a branch being used to do the implementation. And there will be a requirement under the law to have a locally incorporated company to be used for that purpose. So the key issue to note here is that even though there are various legal forms that can be used to undertake projects in Kenya, these can never be looked at in isolation. There are regulatory considerations that will need to be taken into account before deciding on the choice of entity. So for us as tax practitioners, we would then look at what is allowed under the law, regulatory considerations, and then work out the best structure from a tax perspective to ensure that tax efficiencies are created, exit issues that we look at later on are taken into account. At the same time, the project will be able to operate in Kenya. Now, moving on to the next slide, where we'll be looking at funding. So for any of these large projects, funding is always one of the biggest considerations. And at this point, we are assuming an entity has been set up in Kenya. In this case, assuming it's a PPP project, we have incorporated a Kenyan company that will be used to undertake the project. Of course, money has to come in, funds have to flow to then undertake construction so that the project can eventually be implemented and commissioned. So broadly, the funding can come in one of two ways, either by way of debt or by way of equity. There are tax considerations for each of these options. When you're looking at debt, for example, any of the investors who will be putting in their funds into the project will ultimately need a return from those funds. And this return, in the case of debt, will be by way of interest. Interest will be subject to withholding tax at the rate of 15%, but there are exemptions that are available under the law, depending on the type of project that you'll be looking at. So for example, in the energy sector, there is an exemption from withholding tax on interest when paid to non-resident lenders. But even though we have these exemptions in the law, there are other tax implications on the project company itself. So for example, if you fund the company wholly by way of debt, ordinarily interest is a tax deductible expense, and the interest therefore will go to reduce the tax payable by the Kenyan entity. But where the project is funded wholly by way of debt, there are restrictions known as thin capitalization restrictions, which restrict the amount of debt, interest on debt that can be deducted for tax purposes. So in the past, we had a test under the law, which required your debt not to exceed 3 times of your equity. And if it did so, then a proportion of the interest will then not be allowed for tax purposes. Those rules were done away with last year's budget, and a new test was introduced, which limits deduction of interest to 30% of EBITDA, which then means that any interest above this threshold will then not be allowable for tax purposes. At the same time, if you're to get interest-free debt, there are restrictions as well. Deemed interest is applied on interest-free debt from non-resident lenders, and withholding tax implications do arise. Again, there are exemptions that can be relied on, especially in the energy sector. At the same time, the interest that is then charged on these loans cannot be excessive, because we then need to comply with Kenyan transfer pricing laws. And all this means, therefore, is when you have a loan advanced by a non-resident party, in most cases, this non-resident lender will be an entity related to the Kenyan company. So either its wholly owned subsidiary or one of the group entities. So this interest will need to be benchmarked and a basis then adopted to demonstrate that it is not excessive and it is in compliance with Kenyan transfer pricing laws. So having looked at debt, noting that there are a number of exemptions which may be available where the funding is wholly by way of debt, the balance that we normally look at is in terms of ensuring that the investors have a mechanism of extracting profits from the debt in a tax efficient manner, but at the same time, being wary of thin capitalization restrictions, because what this means ultimately is the amount of interest which can be deducted ends up reducing. And potentially, the company could then end up start paying taxes much sooner than would have been expected. So it's a balance, and we work with our clients to look at the financial models to try and see the optimal type of funding to be adopted. When it comes to equity, this is purely by way of shares in the project company, which are then issued to the investors for the funding that is then advanced to the company. When it comes to equity, there are various types of instruments. One of the instruments that we would ordinarily use for this purpose are redeemable preference shares. And these are attractive because they provide a mechanism for profit extraction to the sponsors in a tax efficient manner. Ultimately, it always has to be a balance between debt and equity. But currently, looking at the various generous tax exemptions granted for most of these large scale projects, in most cases, these projects will be funded mostly by way of debt. And one of the exemptions that are also available when it comes to debt is also on the instruments, on the debt instruments. Ordinarily, whenever you have a charge being created and so on, stamp duty would ordinarily be applicable. But but again, as I mentioned earlier, there are exemptions in this regard. These exemptions also extend to stamp duty as well. And we look at some of these issues in detail on the coming slides. If we move on to the next slide. Now, when we then get to the operational phase, at this point, we are assuming that the company has already undertaken the construction and has commissioned the project. And upon commissioning, then there are a number of incentives and allowances which may come in. And then perhaps before I get into the incentives, I probably want to look at on the importation of goods and equipment, which comes prior to finally getting to commissioning and operations. There are a number of exemptions from value-added tax, from customs duty, IDF, and RDL, which will be available for most large-scale infrastructure projects. Now, these exemptions are set out under the law, but they're not automatic. So there is usually a process of seeking these exemptions from the National Treasury, from the Kenya Revenue Authority, to then ensure that when it gets to importation of the goods and equipment through customs, it's then possible to have these goods cleared without payment of duty. There are various complications which will usually arise. In some cases, you need to take out customs bonds to then allow the goods to be cleared prior to duties being paid, because there's usually a bit of a delay in terms of getting exemptions from National Treasury, from the KRA, and having this implemented. But at the same time, goods may have arrived at the port. So there are mechanisms, and we help our clients to then procure some of these bonds and ensure that the goods are released, even as we then try and ensure that the exemptions are granted. Once all these exemptions are in place, project has been constructed, we then get to a point where we then qualify for capital allowances. And broadly how this works is we spent $1 million on a project in Kenya. In the first year of operation, we then qualify for a capital allowance, which is an investment deduction that is an allowable deduction for tax purposes. So if you're looking at simple P&L in the first year of operation, probably the income is not significant because the project company is just kicking off. And bearing in mind that there was an investment of $1 million, we then have $500,000 available as a deduction for tax purposes. And what that then automatically does is in your first year of operation, you then end up with a significant tax loss because your income in the first years of operation is not, will not be significant. But at the same time, you have this massive deduction which is designed to be a tax incentive to encourage investors to put in money and invest in some of these sectors. This tax loss is usually very attractive because it means that provided you're in a tax loss position, you will then not end up paying taxes. And in most cases, you go up to 7, 8 years without being in a tax-paying position, purely because of this tax loss. So in the second year of operation, even though your income is increasing, because of this tax loss that you created in year one, which you deduct for tax purposes, again, your net income that on which you would end up with, again, will have a tax loss, which is again carried forward to the subsequent year. So of course, the tax loss continues to reduce year on year. Previously, the law had a capping of 10 years for carry forward of tax losses. This was removed in last year's budget, mostly because the government introduced minimum tax, which was subsequently suspended by the courts, which is a story for another day. But what we expect is in this year's budget, we have a budget reading later today, we should, it is expected that the capping for the losses will be returned, probably in the 9 or 10-year range, which then means that we will not have an indefinite carry forward of tax losses. But this is one of the most attractive tax incentives for investors in these sectors, purely because it means you're able to push back the due date for paying your taxes by a couple of years. And those funds can be used to reinvest in the project, will be used to repay loans and interest back to the sponsors before the company then gets to a position where it starts paying taxes. This incentive was much more generous in the past, up to a rate of around 150%. But in April of 2020, the government significantly reduced these incentives. But last year, we saw government returning back some of these incentives, but not as generous as they used to be in the past. One of the key issues that we usually look at carefully when it comes to large-scale infrastructure projects is in terms of your EPC contracts. So usually the construction of the project will be undertaken by a third party who will come into the country, undertake construction up to a point where they're ready to have the plant or the project commissioned. And these arrangements will be in such a way that you will have a local component, because ultimately, because the project is in Kenya, this EPC contractor will have people on the ground, work will be done, assuming it's a wind farm, there will be people installing the turbines, undertaking the engineering works in Kenya. But at the same time, there will be a team outside of Kenya undertaking key services such as design. It's the team that will probably source for some of these parts and ensure that there is a seamless integration between what is being done offshore by the offshore team and by the local team, and that the project company ultimately gets its project on a turnkey basis. Now, the issue which arises from a tax perspective is for your EPC contractor, you'd want to ensure that there's a very clear delegation between the offshore scope and the onshore scope. And this is primarily because in the absence of such a delineation, so for example, if we have a situation where you have your EPC contractor undertaking all its work from Kenya and all their payments being made to Kenya, whereas it is ideal for the project company because it's not exposed to any tax risks, the EPC contractor will usually not prefer such a mechanism, because all the income arising from the project will then end up being taxed in Kenya. So in most cases, you will then have the offshore, a legal entity sitting offshore, which will be the offshore EPC contractor, which will then have the scope for delivering on the offshore goods and services, and an onshore entity, which will either be a branch or a subsidiary, which has a scope of delivering on the onshore goods and services. What this then does is it ensures that for the offshore scope, ordinarily for the services element, you will have withholding tax being applicable when paid to an offshore EPC contractor. But there are exemptions in the energy sector where this is in relation to a power purchase agreement. So for an offshore EPC contractor to benefit from this arrangement, they will need to make sure that they are invoicing from an offshore entity, and that at the same time, there's a very clear split as between goods and services. What happens in the absence of a clear split of goods and services, in the event of a dispute with the Kenya Revenue Authority, KRA could end up demanding withholding tax on even the goods element, where the invoicing system is not clear and has not related what is in relation to goods, what's in relation to services, and so on. So this is an area where we spend a lot of time with the project company, with the EPC contractors, trying to come up with optimal solutions which work for the EPC contractor, but at the same time do not expose the project company to unnecessary tax risks in Kenya. And some of these risks that we normally come across in EPC contracts relate to the risk of creating a taxable presence in Kenya. And broadly, this risk will arise where an offshore EPC contractor sends its employees, its agents to come and work in Kenya for an extended period of time without a legal presence in Kenya, or where you have a legal presence in Kenya, but the employees who will be coming into the country are employees of a separate entity who are working in Kenya under instructions of their offshore employer to assist in construction, assembly, or installation of the project in Kenya. This risk, even though it's a risk on the EPC contractor, because what it means is that the EPC contractor then potentially could be liable to taxes in Kenya because of the activities undertaken by its employees and agents in Kenya. What it also means is for the local entity to rely on the withholding tax exemption that I mentioned earlier, it would usually be important to demonstrate that that offshore entity is not undertaking business in Kenya. The moment the offshore entity is undertaking business in Kenya in its own right, not through its local entity, then even the ability to rely on the withholding tax exemption could be challenged. And for that reason, even though this risk is primarily a risk on the EPC contractor, because of the potential risk that it carries on the project company, it then becomes very important to ensure that this is structured correctly. And in terms of the contractual documents, the liabilities and obligations of each of the parties are clearly spelled out. And in the event that the EPC contractor was to then create a taxable presence in Kenya out of their actions or actions of their employees, then ideally they should be in a position to reimburse or indemnify the project company for any liabilities that then they may end up suffering. Looking at the exit or extraction of profits stage, of course, with each and every project, the ultimate goal is to extract profits from Kenya. And as I said earlier, this can be undertaken primarily in two ways: interest on debt or by way of dividends. Now, the challenge with extracting profits by way of dividends is that you can only pay dividends out of taxed profits. And if you recall from the earlier slides, these projects will usually be in a tax loss position for sometimes 7, 8, almost 9, 10 years. Now, during that period, because it is not in a the company is not in a tax-paying position, it is then not possible to pay dividends. But at the same time, as an investor, I would not want to wait up to year 9, year 10 to get a return out of my project in Kenya. That will have a significant impact on the actual return. And therefore, as tax lawyers, what we will do is then put in place mechanisms that ensures that it is possible for the sponsors and for the shareholders and the investors to extract profits from the project company in Kenya from as early on as possible. And primarily, one of the ways that this could be done is through interest. Because for you to pay interest, provided the interest complies with our transfer pricing rules, provided the company does not have a significant impact from a thin calculation perspective, it is possible to then have interest being paid even from year one, provided the company has sufficient cash flows for this purpose. So profit extraction for the initial number of years primarily will be by way of interest. As the company starts to pay tax and has tax paid profits, then at that point it's possible to then pay dividends. But again, it's possible to structure what we call quasi-equity instruments, in this case, which would be redeemable preference shares, which also provide a mechanism. Even when the company is not in a tax-paying position, it is possible to undertake a redemption of some of these shares as a way of repatriating profits to the investors. One of the taxes that has been problematic for a number of years is compensating tax. And broadly, how this tax works is anytime you pay dividends out of untaxed profits, you then end up paying tax at the rate of 30% on those dividends, in addition to withholding tax at the rate of 5% or 15% where the dividends are being paid to non-resident persons. An exemption had been granted to power producers, but this was removed from the laws in April of 2020. And the sole reason why this exemption was introduced is the fact that government grants you a generous tax allowance, which puts you in a tax loss position. And out of no fault of your own, for a period of 9, 10 years, you're unable to, you cannot pay dividends purely because you're not paying tax, but you're not paying tax because the law has granted you an incentive. So because of all those complications, this exemption was granted to then enable project companies in the power sector to be in a position to pay dividends, even while they are in a tax loss position. But with the removal of this exemption, it then means that a power company and any other entity in the infrastructure sector will then be subject to potentially a 30% tax if they were to attempt to pay dividends while in a tax loss position. At exit, and of course, most investors will come in with an exit in mind. Exit can be in a number of ways. In some cases, we've seen exits either happen in Kenya through a sale of shares in the Kenyan entity that holds the project, in which case you will have capital tax at a rate of 5% on the disposal. In less cases, it's happening outside of Kenya, where an offshore holding entity which holds the project company in Kenya is then disposed, the shares in that entity are then disposed to new investors. In that case, except for entities operating in the extractive sector, where even offshore disposal would potentially trigger CTT in Kenya, in other sectors, an offshore disposal does not trigger taxes in Kenya. And therefore, it appears as one of the more attractive ways to undertake an exit, at least until a point where Kenyan legislation would be amended to introduce taxes on offshore disposals. We've seen this introduced in other countries, in Tanzania, and of course in Kenya in the extractive sector. So it's probably a matter of time before blanket CTT is introduced on all offshore exits in Kenya. I'll just pause here. I'll take any questions. This was meant to be a very general overview of the key tax considerations, but happy to deal with any questions that have arisen out of this, or any follow-up questions on any items related to the issues I've discussed. Thank you. There's a Q&A button through which you can send us your questions, and my colleagues will bring this to my attention. I don't think we have any questions as yet. So I'll hand over to my colleague, Nicole, who will look at the land aspects. Of course, if any questions come up during her session, I'm happy to deal with them as well, either through this forum or separately as a follow-up of this session. Thank you very much for your time.
Good morning, everyone. My name is Nicole Kishuri. I'm a senior associate at Anjawala in Ghana. I'm a specialist in real estate and construction, and I also advise a number of project companies and investors in securing land rights for different projects, whether it's in the energy or in the infrastructure sector. So in this session today, we are going to discuss the different methods of acquiring secure land rights, because as you're all aware, securing robust land rights is very crucial to the success of a project. So we'll cover the key land considerations relating to project land. We're also going to cover the modes of securing these land rights, the bankability requirements, and we'll also have a short overview of the land due diligence process. So we'll kick off with the land considerations relating to project land. And I'll start off with the citizenship of the project company or the investor. So this is normally crucial if the land is going to be vested in the project company or the investor. Under Kenyan law, there are no restrictions on foreign companies owning any type of land in Kenya, but there is a restriction on the maximum tenure that a foreigner can acquire, which is restricted to a 99-year lease. There are also restrictions when it comes to ownership of agricultural land, because up to now, the law that restricts foreigners from acquiring agricultural land has not been changed. The permitted user and zoning permissions will also apply. So the project company will also have to factor in what is the permitted user, what are the planning permissions, and what are the kind of approvals that you require from the county and other government authorities in order to utilize that land for the specific project. There'll also be environmental considerations to be considered. So most project companies will be required to undertake some sort of EIA study to confirm, the impact of the project on the surrounding area. There are instances where certain projects have, been stopped or have been delayed because there's going to be an impact on things like flora and fauna, on animals and, the people living in those areas. Then other factors that you have to consider, other than the land required for the key infrastructure, there also need to be consideration given for the facilities or amenities that are going to serve that infrastructure. So access rights and rights of ways to key facilities will also need to be considered when acquiring land for any project. The classification of land is normally one of the biggest issues that project companies face. And we'll discuss this further when we are discussing the land classifications. We'll also go through the bankability requirements in greater detail as we go through the session. So I'll jump straight into the modes of acquiring land for the project. So there are different methods that project land can be acquired. So one of the most popular routes is to acquire the land outrightly, so that the land is totally vested into the project company or the government for PPP projects. And that will be by way of purchasing the land from the existing owners of the property. The other method of securing land rights is through leasing arrangements. So this will vary depending on the nature of the project. Is it a short-term project? Is it a project for life? So for instance, if you're undertaking a road project, it's more likely that there should be an outright acquisition because this is a permanent structure. If the land required is for a temporary period, then a leasing arrangement might be more suitable. The other method, which is not quite popular, but sometimes project companies have to take this route, is by way of licensing. So for instance, if land is required for a project and the land is situated in a forest, depending on whether the forest is titled or not titled, it may be the case that the project company might not be able to do an outright acquisition or a lease of the forest due to statutory restrictions, and the project company might then be compelled to secure the rights by way of a license from the relevant authority. Then one other method which I mentioned at the beginning was rights of way. So there'll be easements and way-leaves, and normally easements and way-leaves are suitable when the project company does not require exclusive use of that property. So for instance, if there needs to be access to a facility, but that access is also used by other parties, whether they're private individuals or public entities, then it might be more suitable for the project company to secure those land rights by way of a registered easement or way-leave, so that the other people who are interested in that parcel of land are also able to utilize the parcel of land. There's also charges is a less popular way of securing land rights, and the reason for that is because charges do not give the project company exclusive possession or any ownership rights over the property. The only security that charges offer is that they actually restrict the landowner from dealing or disposing or creating third-party rights over the project land without consulting or without the express consent of the project company. So we'll also look at the various factors that may determine the mode in which the project company secures the land right. So the factors would vary from project to project. So depending on the type of project, a project company may choose to either buy or lease or license the land required for the project. So for instance, if it's for purposes of a road project, then it might make more sense to acquire the property. Then the size and area of the land required will also determine the mode of acquisition. So for instance, for roads, it makes sense to acquire the property. And then there could be other projects that require a considerable amount of land, and depending on the budget that has been set aside to run the project, then it may make sense for the project company to consider other modes of securing these land rights other than acquisition, because if they do acquire the land, then they'll be required to compensate the landowners at market price, unless they're able to negotiate considerably. Then the commercial and tax considerations will also factor in. So that will be the tax considerations for the acquisition of the land. So if there's an outright purchase, there could be stamp duty obligations unless the project company is able to sort of secure some sort of exemptions from the government. The lifespan of the project will also determine whether you lease or you own land. So as I said before, if it's a short-term project, then it's likely that the project company will take a license over the land or lease the land. If the project is a permanent project, then it's likely that there will be an outright acquisition of the land. The user and zoning restrictions will also determine how the land rights are secured, and also the location of a project site, forest, heritage sites, etc. So it could be the case that if the property is within a forest or a heritage site, the statutory restrictions may restrict a project company from doing an outright acquisition of a project, and they have to consider other methods of securing these land rights. One other method that I had not discussed was concession. So for instance, we've seen for railway line projects, the project companies secure their rights over the land on which the tracks will be constructed and will run by way of concessions. Then we'll delve into the classification of land. So there are three broad classifications of land, and that's normally public land, private land, and community land. So public land is land that is either vested in the national government for the people of Kenya, or vested in the counties. And then there's also private land, which has already been alienated and is held by private individuals or entities. Then there's also community land that is normally held in trust by the various counties for the people in that community. So depending on the category of land, a project company may have to follow certain steps in order to secure land rights. So for example, for public land, there's public land allocation regulations that must be followed before a project company can be vested with public land, and they'll have to meet all the requirements under statute in order to get indefeasible title to that land. When it comes to private land, it's relatively more straightforward, because what the project company has to consider is the contractual agreement between the project company and the private landowner who owns this land. So there are less statutory restrictions in this area, but it might also be protracted, because if you require large tracts of land for a project, then the project company might be compelled to negotiate with each individual landowner that is along the route for the land required for the project. When it comes to community land, this is normally an emotive issue, and the rights of communities to land are secured by the Community Land Act, and the Community Land Act sets out the steps and procedures that must be followed before any community land can either be converted into public land for public use or into private land. So if community land is to be converted for public use, then the government has to go through with the compulsory acquisition process and compensate the community before converting that community land into public land. If the community land is to be converted into private land, then that process has to be done in consultation with the community. And I understand that 2/3 of the adult members of that community must consent to the conversion of that land. Otherwise, the conversion and the use of that land for any other purpose could be contested in future. When it comes to private land, there are some instances where it does not make commercial or practical sense for a project company to negotiate with each landowner along the route. And in PPP projects, you'll find that the project company that has the award will be in talks with the government for the government to acquire that land for the project, and the government will then be required to go through a compulsory acquisition process, make the requisite gazette process and the consultations with all the landowners and other users of that land, and make an award before utilizing the land for the project. Then there are also protected areas. So protected areas would mostly fall within public land, but there are certain protected areas that actually fall within private land. So certain types of protected areas would be, forests, heritage sites, national parks, and areas that have cultural and historical significance. So depending on the statute under which that area is protected, there might be extra requirements before one is able to utilize that land for a project. Then next we look at the bankability requirements for project land. So bankability basically refers to the collection or the basket of issues that issues that must be ticked off in order for a project to reach financial close. So some of the things that generally apply to all types of projects, whether they fall in the infrastructure sector or the energy sector, are A, the project company must be able to show that it has secure land rights, that they have been registered, that there's no third party or who can come and claim or contest the use of that land by the project. I think there are a lot of instances where we've seen projects come to a halt because either the community was not consulted, or a certain statutory process was not followed, or the public participation was not followed through as required, and therefore the use of the land becomes questionable. Then if the land has been acquired by way of lease or outright purchase, there must be favorable terms and conditions for the use of that land and for the payment of compensation to the previous owners, so that the project is able to proceed without crippling the budget. Then whatever land rights have been secured, the documents in relation to those land rights must be back to back with the other project documents. Then there should be no material due diligence issues in relation to that land. So the ownership must be foolproof, the use of the land must be foolproof, the planning provision must also be foolproof. Then, while this is less of an issue for infrastructure projects, the project company must be able to secure securities over the land if possible, because if the project company has secured finances from lenders, the lenders would want to know that they are able to have some sort of recourse where it's possible to the land. Then there should be sufficient warranties and indemnities from the counterparties, including the landowners when it comes to the land agreements. Then the land rights must be capable of being transferred. So if, for example, the project company is unable to fulfill its obligations, the lenders and other counterparties would want to know that these land rights can be transferred to a different company that will then be able to proceed and finalize the project. There are certain additional requirements that must be satisfied if the project company has acquired the land rights by way of a lease structure. And one of the issues that must be that lenders and other investors would look at is that there's adequate term under the lease. So if the term of the lease is, let's say, 20 to 30 years, then the life of the project must be commensurate or less than the term of the lease. Then there should be clear termination rights for a project company if the project company intends to exit or if the project comes to an end. There should be limited termination or revocation rights for the landowner, because if the landowner was to had the right and had the capacity to terminate the leasing arrangement, then the land rights would not be robust. If there's a leasing arrangement, most lenders will want to have direct agreements with the landowner, because if there's an event of default or they want to step in and cure the breaches by the project company, they want to know that the landowner is going to honor that, and that the landowner is not going to terminate the land rights before the lender and other interested parties have the opportunity to remedy the breach. Then there should be adequate cure periods in event of a default. So if there's a default by the project company, you'd want to have an adequate cure period, because if the cure period is too short, then it's likely that the land rights could be terminated, and that will be detrimental to the project. Then we'll also have a very quick overview of the sort of due diligence issues that need to be looked at when one is acquiring land rights. So the ownership of the land will be very crucial. And for this, there are two things to look at: the legal and the beneficial owners. So the legal owner refers to the person who's registered as the owner of that land, because the project company would want to ensure that it is dealing with the person who has the authority and capacity to dispose or grant the land rights to the project. The beneficial owner refers to the person who is beneficially entitled to the land, and sometimes there could be a difference between the legal owner and the beneficial owner in the event there's a trust. And some of these trusts are formed in the event a child is entitled to the property, then their guardian will hold the property for them, or there could be other private trust arrangements. Then the history and chain of ownership is important, because the project company would want to ensure that the whole history of the property is clean, and all the way from the person who was first allotted the land to the person we are dealing with, because if the chain of ownership is tainted at any stage, then that could later come to haunt and affect and impact the project. The registration details of the property would need to be publicly available, and the records would need to match whatever information the owner is giving to the project company. The tenure of the land, whether it's freehold versus freehold, would matter. And while there's not much distinction in terms of from a valuation perspective, it would be important for a project company to confirm that the total term of the land, to confirm the total term of the land versus the residual term, and to confirm that the residual term is enough and sufficient for the life of the project. There would also be development and other special conditions that are tied into the title. So the project company would have to ensure that there are no onerous development conditions that will impact the project. Then encumbrances, so this relates to any charges, caveats, restrictions, or any overriding interests that are tied down to that land. So the project company want to ensure that if any encumbrances are in existence, that all those encumbrances are cleared and discharged, so that the project companies takes unfettered rights over the project company, over the project land. Then the project company will also need to factor in the nature of the consents required. So some of the consents could be on the title documents, or some of the consents required could be from a statutory requirement. So I won't go into details, because this will vary from project to project and will vary depending on the title and the location of the land. So for instance, if you have a project that you want to run that is next to, say, an airport, or say to a river, then you will require certain consents from the relevant authorities to ensure that the intended project does not interfere with the existing land uses. Then there'll also be access rights and easements. So you'll need to factor in whether there are already existing easements and waylifts. If there are none and some are required, then the project company will also have to negotiate and factor this in during the initial stages. Then one of the bigger issues that we see when it comes to acquiring land for infrastructure project is sometimes for large tracts of land, you'll find that there are people who are residing and using the property, and these people do not have any registered rights in relation to the property. And the project company is then faced with the added task of having to come up with a resettlement program that then has to be approved by the relevant county and other authorities. And also they also have to factor in and work out with the government the relocation and the alternative land that will be given to relocate the squatters and other people who are utilizing the land that is required to the project. And in some instances where this is not done right, and the consultation of the people utilizing the land, it does cripple the project, because then there could be sort of, a challenge and resistance from people evacuating the land. Yeah. So I think this does come to the end of a very, very brief overview in relation to acquiring land rights for our project, and I will take any questions. So just give me a minute to see whether there are any questions that have come in from my colleague who is running the Q&A session. So there's a question from the audience. Can you clarify why there are restrictions on foreign ownership of land in Kenya? So I'll clarify this point by saying that under the Constitution, there are no restrictions against foreigners owning land in Kenya. So it's basically an open market for both foreigners and Kenyan citizens. The only caveat is that while citizens are allowed to acquire both freehold and leasehold land, a foreigner can only acquire leasehold land for a maximum of 99 years. The foreigner would then be permitted to apply for a renewal of that tenure subject to complying with certain provisions. I hope that's clear now. And then when it comes to agricultural land, so there's a historical statute that restricts foreigners from acquiring agricultural land. And this goes back to the pre-colonial times when certain land was reserved to be used for the local people. And the local people wanted protection against their land being acquired by foreigners. So there was a statute that was put in place for that and other reasons. So even though times have progressed, that statute has not been reviewed. And there's still a restriction on foreigners acquiring agricultural land in Kenya. So there's a second question. What impacts the choice on a lease versus a license for a project? So if the choice is between a lease and a license, we would advise the project company to take a lease because a lease is more robust. A lease can create, a lease entitles the project company to have exclusive possession of the land for the term of the lease. And a lease can also be registered at the lands registry. And depending on the term of the lease and the nature of the intention of the parties, a lease can actually confer ownership rights because under our land laws, a lease over 21 years with the intention to confer ownership allows the lessee to have exclusive possession of the land and to have some sort of ownership provisions over that land for the tenure of that land. When it comes to licenses, I think they are less preferred because licenses do not technically grant exclusive possession of the land, and licenses are revocable and are not in general transferable. So a license, you'd only take a license if there was a statutory restriction or other prohibition that prevented you from taking a more secure document, such as a lease. The third question is, do you have examples of where community land issues have negatively impacted a project, and how do you deal with this? So off the top of my head, without breaching any confidentiality, I can think of one project down at the coast where the project company entered into agreements with persons who are perceived to be the representatives of the community to sell land to a project company. And the other members of the community then challenged the acquisition of those land rights because the community said they were not well represented and they were not consulted, and that the terms and conditions upon which their perceived representatives had agreed with the project company were not acceptable to the community. And then this delayed the implementation of the project because the rest of the community then went and put caveats against the land, and the project company could not proceed with the project. And they were then forced to commence negotiations with the community, with the other members of the community, even though some money had already passed hands to the perceived representatives of that community. I'm just checking to see if there are any other questions. If there are no other questions, I think we can come to the end of the session. Thank you all so much for attending the session, and we look forward to having more interactions.